I think we're ready to start. Good afternoon, all. Thank you so much for joining us today. My name is Rosa Celorio, for those that don't know me, and I'm the Associate Dean for International and Comparative Legal Studies at GW Law School. And today we will be focusing on issues related to Indigenous peoples, human rights, and legal pluralism. And I want to start with a very special thank you to Laura Calle, who made this event possible, and also to our co-sponsors. We have a number of co-sponsors for this event. We have the International Law Society at GW Law School, we have the Institute of the Americas at Georgetown University, and we have the A. Marseille University as well. And I'm so honored to be joined today by the panelists and speakers that we have. I want to introduce them, give you some information about them, and I think we're all going to benefit tremendously today from their wisdom and experience in this area of the law. So first, I want to introduce Walter Eco Hawk. He's the president of the Pawnee Nation Business Council. As an author, attorney, and legal scholar, he was the Diana Maggie Inouye Distinguished Chair on Democratic Ideals at University of Hawaii Law School. And he has authored a number of books, including The Sea of Grass, In the Light of Justice, In the Courts of the Conqueror. And as a staff attorney of the Native American Rights Fund, he represented Indian tribes, Alaska Natives, and Native Hawaiians on significant legal issues in the modern era of federal Indian law during the rise of modern Indian nations and the tribal sovereignty movement. And Walter has also served as a justice on the Supreme Court, on the Supreme Courts of the Pawnee Nation and also the Kickapoo Nation. And we also have with us Professor Rona Kukkanen. She's actually a research professor of Arctic Indigenous Studies at the University of Lapland in Finland, and also an adjunct professor of Indigenous Studies and Political Science at the University of Toronto. Her research focuses on comparative Indigenous politics and law, Indigenous feminist theory, Arctic governance, and settler colonialism. And she's also a Fulbright Arctic Initiative Fellow for 2021-2022. She was also the founding chair of the Sami Youth Organization in Finland and has served as the vice president of the Sami Council. And she has also long worked and advocated for the protection of Sami sacred sites, particularly Suutasaja, a sacred Sami spring in northern Finland. Needless to say, it is our honor to have them both with us here today. And I just wanted to start by saying, before I pose a few questions to our speakers today, and we're also going to have some commentary from Laura Calle later today, I just wanted to say that the study of Indigenous peoples, legal pluralism, and human rights issues contemplates many issues, many challenges, and many of these matters will be discussed by our speakers today. I mean, one of the things that's very important is the rights of Indigenous peoples to self-determination, self-governance, consultation, and consent as cornerstones of the international law related to Indigenous peoples, the possibility of Indigenous peoples to continue and strengthen their own administration of justice systems as a basic human right, the relationship between ordinary justice systems and the justice systems of Indigenous peoples, the connection of Indigenous people systems with international law and human rights governing individual and collective rights, the impact of the adoption of the cornerstone United Nations Declaration on Indigenous Peoples at the national level, what we call a gender, a feminist, and intersectional components of the rights of Indigenous peoples. And lastly, but not least, and definitely not an exhaustive list, this is a very comprehensive and thorough and very intricate area of the law, is the path towards achieving the effectiveness of international human rights standards related to Indigenous peoples, including contemporary challenges and the steps that are needed. Without further ado, I want to start by asking a first question to Walter Eco Hawk, who's here with us today. And Walter, I wanted to ask you a question related to your work. I mean, in your work, especially in your book, In the Courts of the Conqueror, the 10 Worst Indian Law Cases Ever Decided, you thoroughly explored the dark side of national laws, especially federal Indian law in the United States, by showing how legal standards and rulings have also been used against Indigenous peoples. This is clearly something that other authors have documented in other states in the world. How would you qualify the relationship that Indigenous peoples have with legal systems, not only domestic law, but also international law?
Thank you for that question. I just want to say thank you very much for my opportunity to be here at the law school. I'm very honored to be here from the great state of Oklahoma. And I would just say that historically, the law has been used, or I should say misused, as a tool to bring great harm to Indigenous peoples worldwide. During the colonial era, from about 1492 all the way to 1960, the nations of Europe competed with one another to colonize as much of the rest of the world as possible. And in that 500-year span, all of the Western Hemisphere was colonized, all of Africa, Australia, most of Asia, all of the islands of the Pacific Ocean, as well as the circumpolar world, were colonized by European nations. And so this was a worldwide phenomenon that actually brought great harm and had harsh impacts upon Indigenous peoples who were colonized worldwide, because they suffered the invasion of their homelands, the appropriation of their lands and natural resources, subjugation, warfare, and in many cases, genocide in different forms. And during this period, the legal framework for colonization was the European-based international law of colonialism. That was the legal system that was used to make everything done to Indigenous peoples perfectly legal, according to the European international law of colonialism. So that framework is marked by very prominent anti-Indigenous functions. It comes with doctrines of race, doctrines of racism, doctrines of cultural and religious superiority and inferiority. It comes with doctrines of dispossession, including the doctrine of discovery, doctrines of conquest, doctrines of subjugation, including the just war doctrine, which was legalized the use of force to implement colonial policies, doctrines of second-class citizenship, such as wardship, guardianship, doctrines of plenary power over Native people. And so many of these international law doctrines still remain in effect, even though the institution of colonialism has been rejected as repugnant and oppressive by the United Nations. Many of those doctrines that I just listed continue to survive today in the domestic legal systems of modern nations that were former colonies around the world, that is, the settler states. But today, we do see changes brought about by modern international human rights law to international law that will, I think, as seen in the UN Declaration on the Rights of Indigenous Peoples and some similar declarations, that have begun to repair damage done to Native people and to restore their human rights and indigenous rights that fell by the wayside, and to make international law for the very first time accountable to the world's indigenous peoples. And so that's our historic relationship with international law. Briefly, in a nutshell, as far as the domestic law of modern day settler states, as I mentioned, they inherited, their legal systems inherited and or imported the law of colonialism, in many cases in whole cloth, along with all of these nefarious anti-indigenous features. This includes the legal framework in the United States for dealing with Native peoples, either through federal Indian law on the Indian nations in the lower 48, the Alaska Native legal framework up in Alaska, the Native Hawaiian legal framework, have many of these features that are here today with us that come to us from the medieval origins of the law of colonialism. And the challenge today in these nations is to rid the lingering ill effects of the law of colonialism from our modern legal systems, and to try to find a just balance between the rights, responsibilities, and relationships among Native people and the larger society in these nations. And I do think the UN Declaration on the Rights of Indigenous Peoples helps nations chart that path. And so that's my thoughts to that question in a nutshell. Thank you.
Thank you, Walter. Thank you so much for sharing basically a very negative history when it comes to laws. So I have a connected question actually for Professor Kulkanen, not only in terms of the impact of national laws, but also the impact of international law in this very complicated historical setting. So you have served as Vice President of the Sami Council, and more recently, you have done work for the renewal of the Sami Silda governance system. There are many international and national laws that are applicable to the situation of Indigenous peoples. Could you please share your thoughts on the legal obligations that both states and Indigenous governance systems have with regard to the implementation of international human rights standards? And in your view, are Indigenous governance systems bound by the same obligations as states, or is there a complementarity there?
Parre vielä vuokraita, parre äket. Mulla on Jouna jo nänne Kirsti Räynä, tervodat säämis, tappe tavvin. I just wanted to say hello in the Sami language and greetings from the Arctic Circle, where I'm located at the moment. I used to live in Toronto most recently, but I recently relocated, moved back home, and it's a great honor to be part of this very important conversation. So thank you for the invitation, and thank you to the other panelists as well. But your question, it's a big one, and I assume that we are talking about states' implementation of international human rights standards applicable to Indigenous peoples, particularly. And as I'm sure most of us know that the only binding convention is the binding convention of states is the ILO convention, the Indigenous and 169, the Indigenous and Tribal Peoples Convention. And of the world's states, only 22 have ratified it, mostly Latin American countries, only 3 in Europe. So, but we have the UN Declaration on the Rights of Indigenous Peoples that Walter also mentioned, adopted in 2007. And although it's not a binding convention, it has been increasingly used by various actors and also courts. What I know of, the Canadian even Supreme Court has used it in its arguments. So although it is not a binding document, it's a declaration. So it's considered as a soft law. It is increasingly serving as the framework, not only for Indigenous peoples, like a minimum standards that they can use in their work and advocacy, but also that other non-Indigenous actors are using as the minimum standards and the framework for Indigenous people's human rights globally, that states need to adhere to as good practice. So of course, there's a lot of rhetoric around the UN Declaration, and the states are very eager to demonstrate their, like, talking of the Scandinavian countries are particularly good at talking about or floating their credentials as the human rights defenders on international fora. But when you come to at the national level in their own backyards, it's a very different story. Of course, there are examples of these kind of countries elsewhere. I think Canada is another good example of this. So so states obviously have their international law, conventions, declarations. When it comes to Indigenous governance systems, this is a very interesting question, because first we need to distinguish between the contemporary Indigenous institutions, political and legal institutions that exist and have been established within the Western or mainstream constitutional and political framework, such as the Sami parliaments in the Nordic countries of Sweden, Finland, and Norway, tribal governments in the US, band councils in Canada, and on the other hand, the traditional governance structures that in many cases, like Walter was talking about, were very much, if not completely eliminated, they were disbanded, often violently, radically, well, in many cases even made illegal. But in some cases they are where they exist side by side with state-recognized institutions. Most well-known example is the Haudenosaunee system of clan mothers and hereditary chiefs. So when we talk about the Indigenous governance systems, when we talk about the contemporary Indigenous political institutions, they also typically adhere and are expected to adhere to the international human rights standards, and they also use that framework in the political advocacy nationally and internationally. It's also important to recognize when we talk about international human rights standards and international human rights Indigenous mechanisms, Indigenous rights mechanisms, we have to remember that Indigenous rights advocates since the 70s in particular have been instrumental in redefining the concepts, or some of the key concepts and key with regard to human rights, such as the concept of self-determination, and advancing this idea of collective human rights in international law that's sometimes called like the third wave of rights. If we consider human rights starting from the individual. So Indigenous rights advocates have been key to kind of broaden the horizon and the framework of the human rights, international human rights standards. And finally, what is interesting that when we consider the traditional, the Indigenous traditional governance systems, the language is not of human rights standards, but rather it is the underlying basic and arguably universal principles and values that are used. And this kind of has come up in my own research in very interesting ways, that when I, in my most recent book that came out 2 years ago, I ventured into meanings and conceptions of self-determination. People didn't talk about, and I was interviewing mostly Indigenous women. They did not talk about it in terms of rights or human rights. They talked about it in terms of these foundational values and fundamental principles, such as respect for persons and individual and community well-being, that we can argue that kind of underlie the human rights discourse, but so there is a connection, but the language is slightly different. Like self-determination is not seen, is not always understood, and it is obviously a right, but it's also seen as a foundational value that guides people in their actions as individuals and as collectives, as communities, and that the value that gives rise to imperatives of integrity, which also manifests in many forms. I talk about this concept of integrity with regard to self-determination as well, that it gives rise to this conception of individuals' integrity, but also the foundational importance of integrity of the land, and how these different dimensions of integrity are tied together. So this is kind of like at the first glance is removed from this discussion of implementing of international human rights standards, but we are talking about the same issue, though in different language, and I argue also in a slightly different and more fundamental level often.
Thank you so much for reminding us of the importance, actually, of principles and values. You know, we are at a law school setting, you know, and many of us teach. And when we teach in our courses, we're always thinking about teaching the hard or the soft law on a specific area of the law. But sometimes we don't necessarily teach about those values, principles, and conceptions of human rights, you know, and especially that collective conception of human rights that's so important when it comes, you know, to Indigenous peoples and their human rights. So thank you so much for sharing that with us. Walter, I wanted to go back to you and ask you a question, going back to international human rights law and the potential impact that it has had, or the impact that it hasn't had, you know, at the national level. And I wanted to ask you, especially based on your extensive experience and writings, you know, and also, you know, your experience with the Native American Rights Fund, and also representing the rights, you know, of Indian tribes and Alaska Natives and Native Hawaiians, you know, do you think that the recognition of an instrument like the UN Declaration on Indigenous Peoples and other instruments have had any sort of impact at the national level, at the domestic level for Indigenous peoples, especially the UN Declaration?
Yes, thank you for that question. In my view, the Declaration is a very landmark and a historic harbinger for change. And as a result of the General Assembly endorsement of this declaration and its endorsement by 150 nations around the world, Indigenous peoples today worldwide stand at the confluence between international law and domestic law. And this is a very historic time in the legal history of Indigenous peoples, because we now stand at the dawn of a brand new era, a human rights era. And many of our legal scholars in the United States say that this historic moment is a juris generis, or lawmaking moment in the history of Native American rights here in the United States. And I think the challenge of Native people around the world, as well as nations that have Indigenous peoples, is to begin utilizing the Declaration as a roadmap for social and legal reforms, and to inject the human rights principle into domestic Indigenous law. And we know that on the other hand, however, the devil's always in the details. It's kind of easy to get a law passed, but it's often very difficult to implement the law. And now we're at the implementation stage in many nations around the world, because the Declaration is not a self-enforcing treaty, but rather it's a declaration where the United Nations is asking all of its members to work in partnership and consultation with Indigenous peoples to implement all of these human rights standards into domestic law and policy. And so the progress in doing that, I think, varies from nation to nation. I know up in Canada, here in North America, a lot of the First Nations of Canada are very versed in human rights principles at this time. And those principles and precepts are on the lips of their people in Canada. In the year 2019, British Columbia passed a landmark statute aligning all of the laws in British Columbia with the Declaration. And they also have a lot of litigation going on, a judicial discourse about the nature and content of human rights for First Nations people in the courts of Canada, as well as, I think, a bill pending in their national parliament. So they're fairly advanced, probably the most advanced in North America in implementing those provisions into the domestic law of Canada. Here in the United States, we have not acted as quickly as our relatives to the north. And I believe it was late 2018, the Native American Rights Fund established a joint national project to implement the Declaration into U.S. law and policy. And they're acting, the Native American Rights Fund, which is our country's premier Indigenous public interest Indigenous legal organization, is working jointly with Colorado University School of Law and other partners such as UCLA and others to begin implementing the human rights provisions of the Declaration into U.S. law and policy. They have a website that has you could go to the Native American Rights Fund website. It's un-declaration.narf.org to see the work of this project as it's just getting underway. So I think that the fruits of the human rights provisions of the Declaration remain to be grasped by Native people here in the United States. And we're on our way at the inception of the dawn of the human rights era in the United States in developing a broad-based movement, social justice and law reform movement to implement the Declaration in the United States so that we might inject these human rights principles into domestic law of the United States. So we're at an early stage here in this nation in beginning that march to justice.
Thank you, Walter. And I have actually a connected question about what you just shared with us with Runa about the human rights era, this human rights era in which we're living in when it comes to Indigenous peoples. You have written and researched tremendously about feminist approaches to Indigenous peoples' rights, the role of Indigenous women. And I wanted to ask you to share with us a little bit about why you think a feminist approach or a gender approach or an intersectional approach, to Indigenous peoples is important, in this human rights era, that Walter was just describing for us.
Thank you for that question. Yes, it's an important one. I think a feminist and gender critical gender analysis brings important insights to this human rights era, and there are great scholars who have written about it that I find also useful in the context of Indigenous peoples' human rights and Indigenous peoples' implementation of Indigenous peoples' rights, particularly self-determination. But I also want to emphasize that is also there is when we talk about feminist approaches, I want to perhaps qualify it with Indigenous feminists, because what is often missing from kind of mainstream liberal feminist accounts in particular, there are so many different variants of feminism, but like if we're talking about the kind of like feminist mainstream liberal feminist legal discourse, this understanding of colonialism, the very processes that Walter began in his first discussed in his first answer. So a kind of understanding, and it's very much intersectional, as you said in your question, that you cannot talk about gender without connecting it with questions of colonialism and dispossession, and the various processes, how patriarchy and colonialism go hand in hand, and how, but also recognizing that colonialism was very much a gendered process, which is, I think, one of the key insights and understandings that kind of deepens our understanding of how colonialism has been successful, and how it has been decimating, how it has decimated those very governance structures that I was talking about earlier, that in many cases, if they were not women-led, they were very much women had specific political and economic roles in those structures. So, but to your specific question about the relevance of Indigenous feminist approach to international human rights standards, and what it can bring, in my view, there's several, and I can try to discuss some of them very briefly here. I think it relates to what I already said, that the first one is that Indigenous feminist approach critiques international human rights standards and exposes its blind spots, and such as a limited and partial inclusion of rights imperative to well-being of Indigenous women. UNDRIP, I have taken a critical look at the UN Declaration on the Rights of Indigenous Peoples, and I fully agree with what Walter says, how it is the landmark, and I really like the way you put it, the landmark harbinger of change. I fully agree with that. But at the same time, there is room for looking at it critically and see how we can make it even stronger. Perhaps not. I'm not advocating opening it up to renegotiation, because it took long enough to get where it is, or when it was adopted in 2007. But like in our work, make it stronger, so it pays greater attention to rights specific to women, and attends to specific obstacles Indigenous women experience. And these include rights to reproduction and childbirth, but also minimum wage for domestic and subsistence work, and literacy. These are issues that also kind of more the other feminist legal scholars have raised, that's how this kind of like emphasis on civil and political rights in the public sphere has ignored some of the areas of rights that are important to women's well-being, and we can argue that there are certain rights that are specifically important for Indigenous women's well-being. And also, when we consider these rights, that these specific rights of reproduction, childbirth, minimum wage, and literacy, we can argue, as some have argued, that inclusion of these rights respond responds more accurately to the reality of most women's lives than the liberal feminist strategy of prohibiting discrimination in the public sphere, which kind of like is very limited often to the political sphere, and this idea of equal participation, which is not important to all women or all Indigenous women, important but not the only important issue. Second, rights-based discourses of Indigenous self-determination have also been criticized by a number of scholars for being too state-centric. And Indigenous feminist analysis, in my view, sees that, or as I have argued, that sees that while critical, it's critical, but the unequal relationship with the state, but it's not the only unequal relationship, and it's not the only problem. So an Indigenous feminist perspective can shine light to a broader framework of relations of domination that need to be examined, addressed, and eliminated if we are to achieve an equal standing where Indigenous peoples, all Indigenous peoples, possess and exercise self-determination. And what was very interesting in the research that I did for my most recent book was that how when women were asked about, Indigenous women were, and I was doing interviewing women in Canada, in 3 different regions in Canada and Greenland and in Sápmi, or the Sami territory in Scandinavia, all emphasized the individual self-determination, and many said that is the precondition. These were not seen as oppositional, as often has been, like especially in the past, they've been constructed as oppositional. You can have the other, but not the one, but not the other. But it's like that you need both. And for Indigenous collective self-determination to be possible, you need to have every single member of an Indigenous community need to have individual self-determination. And more recently, there are scholars and activists who talk about body sovereignty and how it's linked to land sovereignty, and environmental justice issues. So making these connections, I think that's one of the contributions that Indigenous feminist analysis can bring to this discussion. And I one thing that I can I don't want to get into too much detail into any of these points, but the fourth one has to do more with the governance institutions rather than human rights standards, and it is I see that it's also critical to pay attention to the gendered structures of political systems when we are setting up Indigenous governance bodies. Political scientists, which is more my background, and to your previous comment, Dean Celorio, that it's important to bring this discussion the kind of more foundational values underlying the rights. I think it's the benefit of not being, my background is not in law, though I always been interested in law. So I like, it's kind of interesting. I always end up hanging out with the legal scholars and doing work. I guess kind of it's on the borderline. I had this conversation with my colleagues here yesterday that I can't differentiate between politics, and especially in the area of Indigenous politics, where the border goes between law and politics. I've been always teaching, when I teach Indigenous politics, I also teach Indigenous, like international law, the UNRIP. But this idea that going back to my idea of the Indigenous political systems, or political systems in general, political scientists talk about path dependency, which means that when you set up political institutions, they very quickly become set in their ways. and it's very hard to reform them once they have been established. And my work has shown that this is very much the case, that Indigenous political bodies follow this same kind of path dependency as well, which is very important to pay attention. Like as Walter was saying, we are now at the stage of implementation. So I argue that it is particularly critical to pay attention to these underlying gender regimes that may become part of Indigenous political and governance systems if we do not pay critical attention to them. So basically, if we do allow those become part of our institutions, then those institutions are are replicating the same exclusions and marginalizations that the mainstream political institutions do. And what I mean by gender regimes, they are these subtle mechanisms, various mechanisms that operate in the institutions that sort of like in various ways exclude women, their concerns, their needs, and also their rights, and which are not changed by adding more Indigenous women, which sometimes been suggested. For instance, looking at the Sami parliaments in Norway, or especially in Norway, where it's headed by a woman, and they like at one stage it was more than 50%, that it doesn't change the structures. And of course, it's not one or the other, that whether women should or should not be participating in the existing structures. It's both and, as always. But they are like, and many Indigenous women do participate, and it's critically important. But then there are other women who say that, why should we participate, and why should we even copy systems that clearly don't work? And this is particularly visible in North America in recent movements such as Idle No More and Standing Rock, and countless other local initiatives where Indigenous women are looking beyond the horizon of existing institutions. And sometimes this means reclaiming or reviving the previously existing structures of deliberation and decision making. And in some cases, this part of this is reclaiming and identifying Indigenous people's own legal orders. There's very interesting work coming out of University of Victoria in particular, and Australia to some extent as well. So what are the kind of like these legal systems that were in place, and how they can coexist today with internet, like national, domestic, and international legal framework.
Thank you so much, Runa, and thank you so much, Walter, for both of you, your remarks, your insight, your contributions today. I want to make sure, for purposes of time, that we have some commentary from Laura, and I want to make sure also that we have some time for questions and answers. But thank you so much for being here today with us. Laura, you have the floor.
Thank you. Well, first, I just want to thank you, our speakers, Walter and Runa, for sharing their knowledge with us today. I would also like to thank Dean Celorio for making this discussion possible, and for giving us the precious opportunity to open spaces like this, especially in these complicated, challenging times and the COVID-19 pandemic. I think the conversation has been truly insightful in a context where, of course, Indigenous peoples around the world continue to fight everyday battles to secure many of their human rights in relation to land and territories, in relation to their cultural and traditional life, or just access to justice, just to cite a few of them. And I believe that this discussion really demonstrated that Indigenous people's rights are still very dynamic. Walter noted that there is an ambivalence of Western legal systems toward indigenous peoples. He noted that historically, the law has been used as a tool against indigenous peoples. And in the meantime, we also see that both speakers insisted on the importance of recognizing specific international human rights for indigenous peoples, especially with the UN Declaration on the Rights of Indigenous Peoples, which constitutes, as Walter say, a historic landmark and a lawmaking moment and in history, especially at the global level. And moving forward, I think this discussion also really illustrated the importance of considering the specific context and the epistemologies in which these rights are grounded. And Rauna noted the relevance of adopting a feminist and critical analysis to human rights. And just to briefly conclude, I think what both our speakers also have shown us is that aside from this ambivalence of legal systems, human rights have also become a space of resistance, and indigenous leaders, groups, and communities have appropriated and advocated for these standards. They have practiced resilience and solidarity to achieve greater representation, both at the local and also at the global level. And in this context, and given the landscape of challenges that were also mentioned by the speaker, I found it actually very powerful to note at various moments during the discussion this importance of genuine commitment toward indigenous rights. And it also raises reflexive questions about how we can understand and practice law in a way that does not perpetuate the inequalities of legal system, but rather in a way that is consistent with social justice ideals. So with all of this in mind, I just want to conclude by saying again that we feel honored that you shared your knowledge and experience with us today. And I really look forward to hearing the questions of other participants who joined us. Thank you so much to all the participants as well.
Thank you, Laura, so much for that commentary. And I actually want to open now the floor for questions. You can write your questions in the chat function. And I see that we have one question. So I'm going to start with that one from the audience. It's from Dan Chalmers. It's, how does the operation of traditional courts, including those that are clan-based by nations like Ho Chunk, illustrate and demonstrate successful ways of advancing today's topics?
Thank you for that question, Don. And that is a good question. I think all of our native nations, have our traditional laws, many of which emanate from the Great Spirit. And there are traditional laws that guide our native people in the habitats, indigenous habitats that we live, where our cultures were incubated and sprung from the soil. And so we do have our traditional laws in many places that are still obtained. And here in the United States, we have over 560 federally recognized tribal nations that are self-governing political bodies within our domestic political system. And each of our nations, for example, I am currently the president of the Pawnee Nation Business Council, which is the governing body of our tribal government. We have our own court systems that utilize, enforce, and interpret tribal law enacted by our tribal government. And also one of the ways in which we're going to be proceeding in the United States to begin this human rights march to justice, I guess you could say, is to do it through our own tribal governments as the first step. We're going to be launching a legislative campaign among our native nations to ask each tribal government to enact statutes, just like the one done by British Columbia, to endorse the declaration and to call upon other jurisdictions, state and federal jurisdictions, to do the same. And along the way, we hope to, because if we don't enact laws embracing human rights, how can we expect other jurisdictions to do that? And so the national project of the Native American Rights Fund and the CU Law School is putting together a tribal toolkit to educate our tribal governments, our tribal attorneys, about the declaration and the need to implement it, and providing model tribal legislation to embrace the declaration and call on other governments to do so. And I think that that's the first step, is to rely upon our own self-government, our own tribal laws to begin launching this march to justice. And now that I think in making a social movement of this nature, it is appropriate to use our tribal governments, self-governing structures, make use of tribal law. But the healing process, I think, in doing that, will be will be found in the implementation, I think, of this declaration. And now that the Trump administration has been repudiated in our nation, we might be able to begin our movement with incubating or fostering a climate for recognizing Indigenous rights, because you have to have conditions of equality and non-discrimination in each society before the recognitions of Indigenous rights can begin. And if you have a society that is engulfed by hate, racism, intolerance, there's no way that you can embrace Indigenous rights, because those are ingredients that incubate conditions for genocide rather than Indigenous rights. And now with this new administration coming into our government, I think that we can begin our march to justice using attorneys of a certain kind, not just any attorneys, but attorneys of a certain kind to lead this, help guide this movement, and to begin by using tribal law.
Runa, do you have anything to add to that question?
No, I don't. No.
Then I'm going to ask the next question, because we have a number of questions in the chat, which is wonderful. It's great to see so much interest. There's one question actually from Natalia da Costa, and she's asking about the Inter-American Court of Human Rights recent decision in the case related to the Laca-Honat Association of basically the members of that indigenous community versus Argentina. And the decision has become very well known because is one of the first ones that really recognizes the justiciability of economic, social, and cultural rights, especially in cases related to indigenous peoples. And she's asking whether you believe this decision respects the indigenous cosmovision, or is it like another way to assimilate the indigenous peoples? And she says this is considering the inextricable link between indigenous peoples and their territories. Could this be a risk for the continuity of their identity in the future?
I'll take a stab at it. I first have to say that I am a domestic practitioner of federal Indian law here in the United States. And I don't hold myself out to be an international law expert. And I'm certainly not familiar with the decision that you've just referenced. And so I really can't answer that. I do know that the OAS, International Court system, has handed down some very good decisions importing human right principles into Indigenous law, and it's probably leading the way, it seems to me, in the Western Hemisphere as far as acknowledging human rights, in the Americas. But I haven't brushed up on those landmark decisions in that court, international court, for today. So, and I'm certainly not familiar with the case that you just mentioned, so I'm not able to really offer a comment on that.
I have another question here, and it's actually from an attorney from the Human Rights Commission. So it's Christian Gonzalez, and he's asking, how should international human rights law treat Indigenous justice systems? Do you think the current response by international human rights law, merely stating that Indigenous justice systems should comply with international human rights law, is enough? It seems that some of the current human rights require a liberal system or a nation state to be implemented.
Thank you for that question. I'm open to all questions as long as they're easy ones. But I think that a lot of people say that they poo-poo, I guess, international law as claiming it's not only alien to many nations, but also that it's unenforceable. And so why have it, I guess? But according to many international law experts, the international law is enforceable, and the primary engines of enforcement are domestic judicial systems. And here in the United States, the federal common law recognizes and enforces norms and customary international law. And so I think that I'm not sure I totally understand the question, but certainly our tribal governments here in the United States, all of the governments of our native nations have their judicial systems, and under the Declaration sees our rights of self-government as an inherent human right, and that includes our judicial systems and our judicial courts, and so these are institutions of self-government, and that's about all I could say. And I think that as a court system that is recognized as a court system by our domestic law, our courts also are in the position of implementing the provisions of international law as in domestic engines of enforcement, at least pertaining to the native nations. So I don't know if that is satisfactory or not, but that's the best I can do at the moment. Thank you.
We have a last question because we've almost reached the end of our event, and it's from Wei Hao. And the question reads, I'm wondering how the domestic laws as well as international human rights laws could better accommodate the needs for both the collective human rights from the perspective of public law and Indigenous women's right to housing or property rights within the Indigenous communities.
I can, I don't think I can answer to that question, but I can recommend a book by Greek legal scholars exactly on that. Like, it's just hot off the press. I guess you can see it backwards, but it's Creating Indigenous Property edited by Angela Cameron, Sari Graben, and Val Napoleon, and they talk about exactly that. I think there is even a chapter on housing from a perspective of Indigenous women. Yes, family homes. So I think that would be a great place to look at. I'm not able to speak to details to that question, but I was thinking of the previous question, and that the question, I'm reading it from rereading it from the chat here, that I think the question is slightly like, I'm wondering if it's a correct way to ask or correct way to put it, that Indigenous justice system should comply with international human rights law. I think that is the wrong question. If we take Indigenous laws, like all laws are ways to respond certain challenges. We could argue that they are responses to universal human challenges. They are ways of responding issues that arise, conflicts that arise in community, ways of attempting to resolve certain disputes and some issues and creating relationships. If we take law, Indigenous law or international law, domestic law, and this is the non-legal scholar talking here, but I like, as the next project, I'm being kind of thinking, like expanding this idea, like I'm very fascinated by this idea of Indigenous law as equal to domestic, like what would they be? How would you go about identifying it? And I mentioned the work at the University of Victoria in British Columbia, where they now have a joint law degree where you can start the common law, do a JD, combined JD in Indigenous law and common law. So it's they are doing exactly that, like taking, putting Indigenous law at the same level as the state law or domestic law, national law, and starting from a premise that these are equal systems of law that are trying to address same issues. So let's look at them. Let's see where the differences are, where the similarities are, and how we can. Often this use the term braiding. How can we use them both? And this is sort of like the ideal of the legal pluralism that we are aiming at. Then the UNDRIP also calls and recommends, urges the governments also and various bodies to recognize that in practice, this is what the legal pluralism would be in practice, that we could practice Indigenous law, and we would have an understanding of Indigenous law. It would not be compliant to the international human rights system or the domestic legal system, but they would be these equal parallel systems that. But we have to often the biggest challenges is the overcoming of this kind of idea that these are customary rights. These are somehow inferior than the, but we can find this if we use even the very law tools to start identifying what these principles are, like what they have been doing in Canada is some Indigenous legal scholars looking at stories. What are the principles, like using the very legal tools, legal scholarship tools to identifying these principles of what is the issue, what is the dispute, what is the law that we can infer from these stories. And it's very interesting work. Like we start seeing that very much the similarities rather than like seeing them as very distinct, far apart systems. So yeah, I think I conclude there.
Thank you so much, Runa, and thank you so much, Walter, for being with us today, for sharing your insight, your wisdom, your remarks. We're very grateful. I also want to thank so much Laura Calle for organizing this event again, for giving us this opportunity today. I also want to thank all of our co-sponsors and also all of you that are present here today. I think we're all working to advance international law and human rights and those principles and values, that have been mentioned by Runa today, and the rights of Indigenous peoples in general. And it's wonderful to be able to have these discussions to identify ways to move forward. Thank you all for being here today. And I also send you all my best wishes for your health, because we're still in the middle of a pandemic and in a very difficult year. And hopefully we can meet in person sooner rather than later. Okay, but thank you so much. Have a good day, all of you.
Thank you.
Thank you so much.